Coming up on Network Africa. South African prosecutors in court to overturn Oscar Pistorius' culpable homicide conviction to murder.
To substitute the finding and sentence. We're asking this court to substitute the finding but refer back for sentence, because I think it would just be fair that if we have a different conviction, that the accused be allowed the opportunity to lead different evidence.
More trouble in Somalia as Al-shabaab militants ambush military trainees barely a day after an attack on a hotel in Mogadishu. Egypt President Abdel Fattah al-Sisi dismisses Islamist militants' claims about the Sinai crash as propaganda. Hello and welcome to Network Africa. I am Adeshewa Josh. Oscar Pistorius' troubled days appear to be far from over. He may be out of the four walls of a confinement, but state prosecutors are seeking a tougher judgment for the Paralympian athlete. At the South African Supreme Court, at the Court of Appeal in Bloemfontein today, prosecutors appealed to judges to overturn the verdict of culpable homicide into murder instead. The appeal is being heard by some of South Africa's most senior judges from across the racial and gender divide. They are, however, not taking any new evidence, but are simply hearing arguments from the prosecution and defense over whether the lower-ranking trial judge applied the law correctly, especially the charge of dolus eventualis, also known as common law murder. In South African law, this charge applies if the accused knew they might kill someone, but still went ahead with their course of action.
The submissions we made is that there was foresight, that a person standing behind a door in a small cubicle, if you fire 4 shots into that, a person will die. And reconciliation in the fact that the accused went ahead and fired 4 shots, not only just 1.
The person on the other side of the door was quite close to the door in that small confined space, and that person was standing upright. Now, even on his stumps, the accused aimed towards bodily parts where fatal wounds could be inflicted. That's the importance of his evidence. And that brings us back to dolus eventualis, which I'm sure we'll deal with thoroughly later.
Yes.
But that's the importance of his evidence, is it not? Forget about dolus directus, we're not there.
I will come to, when you fire shots into a door, what it means.
Bearing in mind that the accused is familiar with firearms, he also uses ammunition to his knowledge, which does great damage to bodily tissue. Those are all factors we must consider.
Well, just a preview of what transpired in court today. Let's take you through main points of the appeal to change the Pistorius manslaughter verdict. 5 judges heard the appeal against Pistorius' murder acquittal. The judges were made up of both blacks and white and women, so it was pretty much a balanced view according to most South Africans. The athlete was not in court. Riva Steenkamp's mother was present, however. Supporters of the athlete were present. The prosecution also wants his jail sentence to be increased from 5 years to a minimum of 15 years. No new evidence is being presented. The judges are to give their ruling on the case in weeks. We're now being joined by our correspondent in South Africa. Betty Dibia joins us now. Thank you so much for making our time to speak to us on Network Africa. We understand the proceedings was aired live on television. Can you describe what really happened in court today?
Well, it was as a lot of people expected. The judges were already privy to the heads of argument that the counsel presented. So they questioned them on that, as well as the judgments of Judge Thokozile Masipa. Mrs. Steenkamp was there, supported by the ANC Women's League and some of her family friends. On the Pistorius side, you had Barry Wu representing, and Harry Nell for the state. And it was as expected interactive. That's what you usually have at the Supreme Court of Appeal, where every single point the judges can stop you and question you, and it's much more interactive than the regular High Court. That was just it. And they were looking at the issue of points of law versus points of fact, and the states can only appeal on a question of law. So they tried to stay careful. They tried to be very careful regarding that issue, to stay on the issue of points of law, so that they don't get trapped. Because if it's the question of the fact, the case may be struck out. So they tried very carefully. But as we heard, the reserved judgment, it could be in a few weeks, it could be after. But we know that it's almost the end of the year, so they may try to round it up earlier or later. Now,
we understand the judges did not take any new evidence in court today. Of course, they're only arguing technicalities. What were the responses of Oscar Pistorius' lawyer to the case made by the prosecutors in court today?
It was quite a little tough or rough for Barry Wu, who represents Oscar or the defense, where he tried to justify the fact that there was really no need to take this further or just leave the status quo, which, as I said earlier, was expected of him. But the judges questioned a lot of issues, especially where Harry Nell raised the issue of the judge ignored evidence. Even the testimony of, they raised the issue of the ballistics expert and all that. But we remember Judge Leach asked whether there was any other thing besides the noise to show that Oscar's life was in danger. He tried to argue on that and said, and push the issue of the state of mind. And I remember Barry Wu saying 14 injury or death doesn't provide insight into the state of mind of the accused, or in this case, Oscar Pistorius. So it was a little tough and rough for him, but he scaled through, and we're watching to see how the judge. But what you saw in court doesn't mean it will go again. So the outcome we're expecting, either a retrial, which may be difficult to get, a murder conviction, or leave the status quo. That is, he finishes his 5-year conviction in house arrest.
Well, thank you, Betty Dibia, there for us from Johannesburg, South Africa, giving us the latest on the Oscar Pistorius appeal. Let's now bring into the studio a legal practitioner, as Chukwemeka Eze. He joins me now in the studio. You've heard what our reporter said from South Africa. So much was argued in court today, no new evidence. What are your thoughts on the arguments of the prosecution in court today?
I tend to align myself with the prosecution because the size of the toilet is so small that someone couldn't have run to any place to hide. And by the time he fired 4 shots, he well knew that certainly somebody there would be harmed. So the intent, the mens rea, whether Oscar Pistorius had the mens rea, the Tokosile Masipa, the judge that had decided the matter previously, the trial judge, it came to a conclusion that the intent was not there, the dolus eventualis was not there. But it seems to me that it was there. This is somebody who was not in danger, and at the time he did not shoot only once, he shot 4 times. So he knew the consequence of his action, and he persisted in ensuring that that consequence came to pass. So basically, I quite agree with the prosecution that he knew the consequence, and he ordinarily should be convicted for murder.
But then again, a lot of people are saying that the trial judge, that's the Mr. Tokosile, I beg your pardon, misinterpreted the law, which is the dolus eventualis. Do you agree that she misinterpreted it?
I agree. That's the position.
Why
That's why
do you agree?
I align myself with the position of the prosecution. Because from the pieces of evidence, certain things were established, and they are not in controversy. One of which is that he was not in danger. That's 1. 2, he shot 4 times. That's 2. 3, he had a quarrel with the girlfriend, the late River Steenkamp, and he was used to usage of ammunition. So if you piece all these factors together, you will discover that he had the mens rea, he had the actus reus. So he had the intention to kill, and he carried out the killing. So the whole thing had come to a head.
You know, one of the arguments in court during his trial was that he may have had the intent to kill, but maybe not that particular person, because they also argued that he could have thought he was in danger. Are these possibilities in this case?
Once it is established that he had the intention to kill, he will go in for murder, whether he intended to kill River Steenkamp or someone else. In
self-defense?
There was no self-defense. Self-defense over what?
You know, he argued that he felt threatened.
I mean,
as an amputee.
That feeling, is it reasonable in the circumstance? That feeling is not reasonable, because anybody can say, because I'm an amputee, I felt threatened, and because of that I had to shoot somebody to kill somebody. So that argument, no matter how we look, is subjective. It seems to me that that argument shouldn't have been accepted by the trial judge, because he was not in danger in any way, even prior to the shooting. So, and the toilet, like the judges at the Supreme Court of Appeal have asked the parties today, I mean, the toilet is so small, where could somebody have hidden if you are shooting to scare somebody away? So there was no way somebody could have run away from there or even hid somewhere. So by the time these 4 shots were fired, it was conclusive that the person firing it knew that he was firing to kill somebody. Once the intention is established, because in the trial, the intention was not established. That was why he was convicted for culpable homicide. That's manslaughter in our own context in Nigeria, but over there in South Africa called culpable homicide. Ordinarily, if that intention was established, he would have been convicted for murder. And that is what the prosecution is asking the Supreme Court of Appeal to do today.
Exactly, and that brings me to the prosecutor, because of course the defendant, that's Oscar Pistorius' lawyer, right? How best can he argue this case in favor of Pistorius?
I think it seems to me the best way he can argue it is this, that the appeal is not based on mixed facts and law, that is entirely based on law. And there is no way the prosecution's case can be looked at without looking into the facts. And since South African law does not allow for this type of appeal, for it to be examined on the facts, then that the Supreme Court of Appeal should throw away the case on technical grounds that there is no way to be looked at without looking into the facts of the case. And since the Supreme Court of Appeal should not bother itself with the facts of the case, it's just to find out whether the finding was perverse or not perverse, and whether the judge misdirected herself or did not misdirect herself. And there is no way, or whether the judge erred in law or did not err in law. So if it is that the judge erred in law, definitely issue of facts wouldn't be there. But if you begin to look at misdirection and findings of facts, whether perverse or not, definitely you go into issue of facts. So I expect the lawyer for Oscar Pistorius to argue that since there is no way, my learned justices, there is no way you can look at this thing without veering into the facts. The best thing is to throw away this matter.
Is that how you would have won this case?
That's the way I would have argued it.
Okay, so
if I was standing in for him.
Right. Where do you see this end up? Because if the prosecutors win this case, if the ruling that we're expecting in weeks go in favor of the prosecutors, Oscar Pistorius might end up in jail for
15 years.
15 years.
Yes.
Where do you see it go based on the arguments today in court?
I'm thinking that the whole thing, sympathy will come in somewhere, even though without stating so directly. It will not be said in open court. But I doubt whether this Paralympian will be made to face murder, the murder charge, because that will definitely doom him.
Chukwuemeka is a legal practitioner. Thank you so much for helping us to understand the technicalities of this case. Before I go on a short break on Network Africa, let's quickly take you through what Pistorius was and wasn't originally convicted of. Premeditated murder, was acquitted of common law murder, illegal possession of ammunition, but he was found guilty of culpable homicide, which is also manslaughter, as we know it here in Nigeria, and discharging firearms in public. When we come back on Network Africa, President Pierre Nkurunziza orders all Burundians in possession of illegal firearms to hand it over latest on November the 7th or risk being charged for treason.